Hello and welcome to Mandatory Reporting of Child Maltreatment, training for all school employees. Completion of this training fulfills the statutory requirement for school district employees to complete training by the Wisconsin Department of Public Instruction on the topic of child abuse and neglect. The Wisconsin Department of Public Instruction extends its appreciation to the Wisconsin Department of Children and Families for its help in creating this training. This is one of several successful collaborations between these two state agencies to keep young people safe and improve their educational outcomes. This presentation will cover the following kinds of child maltreatment: neglect, physical abuse, emotional damage, and sexual abuse. Examples of signs of these different forms of child maltreatment will be shared. This presentation will also describe situations and behaviors that are sometimes mistakenly considered to be child maltreatment, how to make a report and what to report, what you can do if you are not sure if you need to make a report, and where you can get more information. Statutory citations are included in this presentation when appropriate. There are signs of child maltreatment to be aware of, but these signs can also indicate other circumstances involving medical conditions, poverty, or accidents. Generally, the more signs we see, the more concerned we are. Keeping a log of observed concerns can be helpful in demonstrating a pattern. Ultimately, whether you make a report for suspected child maltreatment depends on the signs you observe, comments by the student, and interactions with the family. State statute defines neglect as the failure, refusal, or inability of a parent or other caregiver, for reasons other than poverty, to provide for the basic needs of a child to the point that it seriously endangers a child's physical health. Neglect can be related to inadequate food, clothing, shelter, medical or dental care, or supervision. In addition to parents and guardians, caregivers include other relatives, including older siblings, foster parents, child care providers, babysitters, teachers and other educators, and live-in partners of parents, even if they care for the child only occasionally. Neglect can be demonstrated in different ways. Some signs of neglect include regular or frequent, poor hygiene or body odor, being inappropriately dressed for the weather, needing medical or dental care, being left alone and unsupervised for long periods, arriving early and staying late at school, habitual absences from school, listlessness or fatigue, hunger, especially a student who begs, steals, or hoards food, failure to thrive or malnutrition, and extreme willingness to please others. You can use the signs just described and these questions to help determine if a report needs to be made. How many warning signs do you see? Are the warning signs regular or frequent? Remember, the student's physical health must be seriously endangered for the situation to be considered neglect. Let's look at physical abuse now. State statute defines physical abuse as a physical injury inflicted on a child that is not an accident. Physical injury includes, but is not limited to, lacerations, fractured bones, burns, internal injuries, severe or frequent bruising, or great bodily harm. It is important to note that the injury must be severe enough to meet this definition of a physical injury in order to be considered physical abuse. Corporal punishment that does not result in a physical injury does not meet the statutory definition of physical abuse. However, bruises on the face or head are almost always considered serious. It is important to note the person need not intend to injure the child for a resulting physical injury to be physical abuse. Examples of physically abusive behavior where the person did not intend to injure the child include shaking a crying baby out of frustration, jerking a child by the arm and dislocating the elbow, and corporal punishment that results in bruises or welts. Children commonly get bruises and bumps on their knees, elbows, and forearms from accidents during play and other activity. Bruising that is less likely to be from accidents includes bruises around the cheeks, abdomen, thighs, neck, back, or midway between the wrist and elbow. Bruises that are different colors, which can mean injuries over time. Bruises that are in the shape of an object, and bruises on multiple parts of the body. Other signs of physical abuse include injuries in the shape of an object, for example, a belt or an electrical extension cord, unexplained burns, a delay in seeking needed medical help for the student, extremes in behavior, the student is very aggressive or withdrawn and shy, the student is afraid to go home, and the student is frightened of the parents or other adults. You can use the signs just described and these questions to help determine if a report needs to be made. Does the student's explanation for the injury make sense to you? Is the student evasive about sharing how the injury occurred? Now, let's learn about emotional damage. Unlike many other states, Wisconsin's Children's Code does not provide a definition of emotional abuse. Rather, our state law defines emotional damage as harm to a child's psychological or intellectual functioning that is observed in anxiety, depression, withdrawal, or aggressive behavior exhibited to a severe degree, or a substantial change in the child's behavior, emotional response, or thinking that is not normal for the child's age or development. Educators are to report if they see warning signs of emotional damage in a student, and the parent has not obtained treatment for the child or taken other steps to improve the child's symptoms. Some signs of possible emotional damage include low self-esteem, self-denigration, severe depression, unusual level of aggression, severe anxiety, extreme withdrawal, and failure to learn. Self-destructive or delinquent behavior of adolescents may also be signs of emotional damage, including abusing alcohol or drugs, an eating disorder, talk of suicide, or self-injury such as cutting. You can use the signs just described and these questions to help determine if a report needs to be made. Does the student demonstrate anxiety, depression, withdrawal, or aggressive behavior to a severe degree? Has the parent obtained treatment for the child or tried some other way to improve the child's symptoms? Now let's look at sexual abuse. State statute defines sexual abuse by referencing different forms of illegal sexual behavior or conduct with a child, and includes any inappropriate sexual touching. Specifically, sexual abuse includes fondling or exposing genitals, either the abuser's or the child's, sexual intercourse, sexual exploitation, exposure to pornography, having a child view or listen to sexual activity, and allowing, encouraging, soliciting, recruiting, or transporting a child to engage in prostitution or attempting any of these acts. It is important to note the requirement to report the trafficking of children and adolescents for commercial sex is effective May 29, 2017. Possible signs of sexual abuse include extreme secrecy, compliance, or withdrawal, an unusual fear of people from one gender or with specific characteristics such as a deep voice, very seductive behavior or unusual interest in or knowledge of sex for the student's age, and refusal to take part in gym or other activity. Other signs of sexual abuse are sexual play among young peers that goes beyond curiosity, physical symptoms that might indicate an injury that could be related to sexual activity or a sexually transmitted infection, poor peer relationships, and a drastic change in school performance. It is important to note that sexual curiosity and behaviors that are developmentally normal for pre-adolescent children are not sexual abuse. Situations involving sexually active adolescents may have to be reported depending on these three factors: whether the sexual activity is voluntary or involuntary, the age of the student, and whether the student has accessed healthcare services, such as seeking out information about birth control or treatment for a sexually transmitted infection. This complex topic is specifically addressed in these two resources from the Department of Public Instruction: the online module Mandatory Reporting of Child Abuse and Neglect, Supplemental Information, and the publication Reporting Requirements for Sexually Active Adolescents. Both of these resources can be found at the website on this slide. You can use the signs just described and these questions to help determine if a report needs to be made. Has the student had sexual contact with another person? Has the student been exploited sexually in some way? Has the student been exposed to sexual content? Has the child been trafficked for sex purposes? It is important to distinguish between what is and is not child maltreatment. Failure to give prescribed medication to a child is not abuse or neglect unless it threatens the child's life or health. For instance, a parent who declines to provide stimulant medication to a child with attention deficit hyperactivity disorder, or ADHD, is not threatening the life or health of the child, and a report should not be made. However, a parent who declines to provide insulin to a child with diabetes may be threatening the life or health of the child, and a report should be made. Truancy is not child maltreatment under Wisconsin law, and school districts should follow the provisions in Wisconsin Statute 118.16 in situations involving students who are absent from school for unexcused reasons. As we learned earlier, situations involving actual or threatened self-injury by a student, such as cutting or suicide threats, are not child maltreatment unless the student demonstrates symptoms of emotional damage and the parent has refused to obtain necessary treatment for the student. Now let's learn about making reports of suspected child maltreatment. A school district employee is legally required to immediately report to County Child Protective Services or local law enforcement if the educator has reasonable cause to suspect a child the educator has seen as part of their work has been abused or neglected, or has been threatened with abuse or neglect, and the educator believes it will occur. Reports are to be made by the person who has first-hand knowledge of the child's behavior, comments, or observed injuries that cause the person to reasonably believe the child may have been abused or neglected. It is important to note that you are not to determine if child maltreatment has actually occurred or not. You just have to have a reasonable cause to suspect that child maltreatment may have occurred or may occur in the future. Your statutory requirement to report only applies to students you see in your work setting. You are not legally required to report situations of child maltreatment you may observe in the neighborhood where you live or other parts of your community, for instance, the grocery store. Some adults in school are not required to report suspected child maltreatment. These include contracted staff, for instance, bus drivers, and volunteers who work directly with students. School districts may choose to extend expectations to notify appropriate school authorities of suspected child maltreatment to all contracted staff and volunteers through local school district policy. You can fulfill your statutory obligation to report possible child maltreatment by contacting either County Child Protective Services or local law enforcement. You do not have to contact both systems. However, law enforcement is generally contacted if there may be immediate danger to the student. If there is no immediate threat, you should contact County Child Protective Services. Wisconsin law requires reports to be made immediately, by phone or in person. Do not wait for a convenient time in the school day or until the end of the school day to make a report. The law prohibits anyone who makes a report in good faith from being fired, disciplined, or otherwise discriminated against in regard to employment, or from being threatened with any such treatment. A reporter is protected from both civil and criminal liability. A report for suspected child maltreatment by a mandated reporter is confidential. The county, local law enforcement, and the school district may not legally share any identifying information about a school employee who makes a report, unless the disclosure is specifically authorized in the law. Penalties for failing to report or sharing information that identifies a reporter without authorization include fines up to $1,000 and up to 6 months in jail. Whether a report must be made sometimes depends on who is suspected of maltreating the child. Neglect should be reported only if it involves a caregiver. Emotional damage should be reported only if the parents are suspected of not seeking treatment that the student needs. However, physical or sexual abuse must be reported regardless of who, if anyone, is suspected of being involved. It is common to be unsure if a report should be made in any given situation. It is a good practice to talk to someone else who can help to determine if a report is necessary. There are a couple of ways you can do this. Pupil services professionals and school administrators may have additional experience and expertise in this area to help make the decision. You can call County Child Protective Services or local law enforcement and explain the situation without mentioning any names to help determine if a report should be made. Talking to someone else may not delay a report. For instance, you may wish to consult with a pupil services professional, but if that person is not in your building that day and you cannot reach her or him by phone, you should not wait until the next day. You need to find someone else to consult with or make the decision on your own. Ultimately, the decision to report is to be made by the person who has first-hand knowledge of the student's comments, behavior, or observed injuries that may indicate child maltreatment has occurred. Another person, including a supervisor, may not legally prohibit you from fulfilling your legal obligation to report possible child maltreatment. When you make a report, County Child Protective Services and local law enforcement will want to know the following information: information about the student, parent or parents, other household members and siblings, and suspected abuser, including names, addresses, relationships, phone number, and the student's date of birth. Have this information readily available when you call in the report. Specifics of the observed injury, including what the injury is and where it is located on the student, and any statements made by the student that lead you to reasonably suspect child maltreatment may have occurred. Other information County Child Protective Services and local law enforcement will want to know when you make a report include any prior concerns you may have about possible mistreatment of the student that may not have required a report at the time, special needs the student may have, and relevant cultural context, if any. Be prepared to offer this information when you make a report. Does the suspected perpetrator have access to the student? Do you have any concerns for the student's immediate safety? Does anyone else know about the suspected abuse or neglect? Are there other children in the household? If so, what are their ages? It is common for County Child Protective Services and local law enforcement to ask questions about students that involve information from the student's confidential records. Frequent questions include: is the student in special education? How is the student's attendance? There is no express authorization to share information from pupil records in state or federal education records laws as part of a child maltreatment investigation. However, information from pupil records may be shared to protect someone's health or safety in an emergency. In a 2015 decision, the U.S. Supreme Court characterized a report and subsequent investigation of suspected child maltreatment as an ongoing emergency. A school district's legal counsel can help to determine if school district employees may respond to questions from County Child Protective Services or local law enforcement as part of making a report for suspected child maltreatment. When you make a report, you may ask the intake worker questions. For instance, what will happen next? Do you plan to interview the student? If so, when? You may wish to document your report, including the following information: date of the report, what you reported, what agency you reported to, and the name and contact information of the person you reported to. You can learn more about reporting possible child maltreatment from the Wisconsin Department of Public Instruction and the Wisconsin Department of Children and Families at these websites. You can also learn more by contacting your County Department of Social Services, police school liaison officers or other local law enforcement officers, or school counselors, nurses, psychologists, social workers, and administrators.